This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about why health insurance benefits promised by a city are never available forever, and why the City of New York's Medicare Supplement Plan was properly discontinued and replaced by the City of New York, with New York's highest court approving the change in the city's Medicare plan. The City of New York decided to discontinue its Medicare Supplement Plan, Senior Care, and enroll all retirees in a custom-designed Medicare Advantage Plan, a MAP, managed by Aetna Life Insurance Company. Petitioners, consisting of 9 retirees and 1 organization, initiated legal proceedings to prevent the city from eliminating their existing health insurance plans. They argued that the city had repeatedly promised to provide and pay for Medicare's supplemental plan upon retirement, and that they relied on these promises when making financial, employment, and retirement decisions. In the Matter of Robert Bentkowski et al. Versus the City of New York, 2025 New York Slip, Opinion 03690, the New York Court of Appeals on June 18, 2025, ruled in favor of the city. The Supreme Court, the trial court, ruled in favor of the petitioners on their promissory estoppel cause of action and their cause of action under Administrative Code of the City of New York, and the appellate division affirmed. The city appealed to the highest court of the state, the Court of Appeals. The primary issue before the Court of Appeals was whether petitioners were entitled to judgment on their promissory estoppel cause of action. The Court of Appeals concluded that the petitioners were not entitled to judgment on this cause of action, as they failed to establish the existence of a clear and unambiguous promise of Medicare supplemental insurance coverage for life. The court found that the summary program descriptions, the SPDs, provided by the city were descriptive and for information purposes only, and did not constitute a clear and unambiguous promise of Medicare supplemental insurance coverage for life. The affidavits submitted by the petitioners, including those from Lilian Barros Paoli and hundreds of retirees, were based on the SPDs and did not establish a clear and unambiguous promise. The petitioners contended that the city was required to provide and pay for a Medicare supplemental plan under Administrative Code Section 12-126. The court rejected this contention, stating that the requirement prohibits the city from passing any portion of the cost up to the statutory cap on its employees and retirees, but does not require the city to fund health insurance without the benefit of federal subsidies. The court reversed the order of the appellate division and remitted the matter to the Supreme Court for further proceedings in accordance with its opinions. The respondents argued, among other things, that the city's statements in SPDs do not constitute a clear and unambiguous forward-looking promise sufficient to support a promissory estoppel claim. Furthermore, respondents stated that the Aetna map was the product of negotiation between the city, Aetna, and the Municipal Labor Committee, which represents over 100 municipal unions in the collective bargaining process. According to respondents, the Aetna map would allow the city to access federal subsidies, creating $500 million in savings to be allocated to a health benefits stabilization fund to provide sufficient reserves for future health benefits. Any inference of a lifetime promise derived from the SPDs is even less plausible in light of the prefatory language employed therein in the mayoral cover letters, because there is no clear and unambiguous promise in the SPDs, the affidavits of Barros Paoli, and the hundreds of retirees likewise failed to establish the existence of such a promise. The parties stipulated to the completeness of the record, and on that record, petitioners failed to introduce sufficient evidence to establish that the city's decision to shift retirees to the Aetna map constitutes a diminution in retiree benefits or the city's contributions for those benefits. Therefore, the order of the appellate division was reversed with costs, and the matter was remitted to the Supreme Court, New York County, the trial court, for further proceedings in accordance with the opinion. In my opinion, promises to provide health insurance coverage and Medicare supplement coverage must be clear and unambiguous. To provide such services for the life of the employee or retired employee for a court to compel the city to keep the promises. The promises of coverage were not kept because they were not made to be a forever benefit. Shifting benefits from one program to another did not diminish the benefits promised, and the retirees still had Medicare plus extra coverages. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you'll gain access to the more than 5,100 blog postings. Please tell your friends and colleagues about this blog so that they too can subscribe. And you can also subscribe to these videos on rumble.com and youtube.com. And if you do, I'd appreciate it if you click on the thumbs up button on Rumble or the like button on YouTube. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publications. Thank you for your attention.